Hello, I am Assistant Professor Vidya-mitra. The objectives of this module will be to understand the historical background for setting up of the European Court of Human Rights, to understand the structure, process of submitting of applications and complaint procedure, to look into protocols 13 and 14. The European Court of Human Rights, in other words the court, is a regional human rights judicial based body in Strasbourg, France. It has delivered more than 10,000 judgments on violations of the European Conventions on Human Rights and Fundamental Freedoms Convention. In 1998, the human rights system was reformed to eliminate the European Commission of Human Rights, which previously decided admissibility of complaints. It also oversaw friendly settlements and referred some cases to the court in manner similar to current inter-American systems of human rights. It is to be kept in mind that the court was established on 21st January 1959 on the basis of Article 19 of the Convention. Delegates to the court with ensuring the observance of the engagements undertaken by the contracting states in relation to the Convention, its protocols, and the enforcement and implementation in the membership. The membership state councils of Europe. In 1998, the court became a full-time institution and the European Commission of Human Rights was abolished. Since then, individual victims may submit their complaints directly to the court. The number of full-time judges are 47. The convention requires that judges be of high moral character and to have qualifications which are suitable for high judicial office, or be a jury consult of recognized competence. Judges are elected by a majority vote in the Parliamentary Assembly of the Council of Europe from 3 candidates. These candidates are nominated by each contracting state. Whenever a sitting judge's term has expired or when a new state becomes a party to the convention, the retiring age of judges is 70. But they may continue to serve as judges until a new judge is elected. It is to be kept in mind that the judges perform their duties in their individual capacity and should not have any institutional or other types of ties with the contracting state on behalf of whom they were elected. A judge cannot hear or decide a case if he or she has a family or professional relationship with the parties. A judge can only be dismissed from office if the other judges so decide by a 2/3 majority. Judges used to be elected for a 6-year term, renewable once. Protocol 14 showed that entered into force in 2010, amended this, and now judges serve one non-renewable 9-year term. The judges work in 4 different groups or judicial formations. These judicial formations are as follows. First, single judge only rules on the admissibility of applications that are clearly inadmissible based on the material submitted by the applicant. Second, committee. This is composed of 3 judges. Committees rule on the admissibility of cases as well as on the merits when the case concerns an issue covered by well-developed case law. The decision must be unanimous. 3. The chamber. The chamber is composed of 7 judges. Chambers primarily rule on admissibility and merits for cases that raise issues. Issues are those issues that have not been ruled on repeatedly. A decision, kept in mind, may be made by a majority. Each chamber includes the section, president, and the national judge. The judge with the nationality of the state against which the application is lodged. The fourth is the Grand Chamber. The Grand Chamber is composed of 7 judges. The Grand Chamber hears a small, elect number of cases that have either referred to it or relinquished by a chamber. Apart from these 4 chambers, there is also a plenary court, an assembly of all the court's judges. It has no judicial functions but elects the court's president, vice president, registrar, and deputy registrar, and deals with various administrative matters. Discipline, working methods, reforms, the establishment of chambers, and the adoption of the rules of court. It is to be kept in mind that copies of all relevant documents must be included along with the application. The proceedings before the court are conducted primarily in writing. Public hearings are extremely rare. There is no cost associated with submitting an application, and the applicant may apply for legal aid to cover expenses that arise in the proceeding. While a lawyer is not necessary to lodge a complaint, applicants should have representation after the case is declared admissible and must be represented by a lawyer in any hearing before the court. Applications to the court go through 2 phases: admissibility and merits. To be declared admissible, an application must meet the following criteria. The first is exhaustion of domestic remedies. 6-month application deadline from the final domestic judicial decision. Complaint against a state party to the convention application suffered a significant disadvantage against one or more of the states which are bound by the convention, and which has or have through one or more act submissions violated the European Convention on Human Rights attributed to one or more public authorities in the state concerned. For example, a court or an administrative authority alleged violations may cover a wide range of issues, such as torture and ill treatment of prisoners, lawfulness of detention, shortcomings in civil hearings or criminal trials, discrimination in the exercise of a convention right. Then you have the parental rights, respect for private life, family life, the home, and correspondence. Restrictions on expressing an opinion or on imparting or receiving information. Freedom to take part in an assembly or demonstration. Then there is expulsion, extradition, confiscation of property, and expropriation. The jurisdiction of the court is divided into A. Interstate cases, where a contracting state of the convention can bring an action against another contracting state. Applications by individuals against contracting states. These can be made by any person, non-governmental organization, or groups of individuals. Advisory opinions are requested by the Council of Europe by a majority vote, asking the court to deliver. They are basically to deliver opinions on the interpretation of the convention. A preliminary finding of admissibility is essential. On a preliminary finding of admissibility, the court examines the case by hearing representations from all parties. The court may undertake an investigation if it deems it necessary on the facts or issues raised in the application, and contracting states are required to provide all necessary assistance. The majority of cases are heard in private following written pleadings in confidential proceedings. It is to be kept in mind, in confidential proceedings, the court may assist parties to secure a settlement in which the court monitors the compliance of the agreement with the convention. Then you have the Cotes Chamber. The Cotes Chamber decides both issues regarding admissibility and merits in the same judgment. Then there is the final judgment. The court makes a declaration that a contracting state has violated the convention and may order the contracting state to pay material and or moral damages and the legal expenses as and when it has incurred. The court's judgments are public, and whenever a decision is given, it must be a reasoned decision. Any judge who has heard the case can attach to the judgment a separate opinion. This opinion can concur with or dissent from the decision of the court. It is to be kept in mind that Articles 46 of the Convention provides that contracting states undertake to abide by the court's final decision. On the other hand, advisory opinions are by definition non-binding. The court has to decide consistently that under the convention it has no jurisdiction to annul domestic laws or administrative practices which violate the convention. The Committee of Ministers of the Council of Europe is charged with supervising the execution of the court's judgments. The Committee of Ministers oversees the contracting states' changes to their national law. This is done so in order that it be compatible with the convention. In 1999, 8,400 applications were allocated to be heard. In 2003, 27,200 cases were filed. A number of pending applications rose to 65,000. In 2005, the court opened 45,500 cases, and 2009, 57,200 applications were allotted, with the number of pending applications rising to 119,300. Protocol 11 was designed to deal with the backlog of pending cases by establishing the court and judges as a full-time institution, by simplifying the procedure and by reducing the length of proceedings. As far as the workload of the court, it continues to increase. In May 2004, the Committee of Ministers adopted Protocol 14 to the Convention. This protocol was done with the aim of reducing the workload of the court and of the Committee of Ministers in supervising the execution of judgments, so that the court could focus on cases that raise important human rights issues. Protocol 14 entered into force on 1st June 2010. Protocol 14 led to reform in 3 areas. 1. The court's filtering capacity was reinforced to deal with clearly inadmissible applications. Second, new admissibility criteria were introduced so that cases where the applicant has not suffered a significant disadvantage would be declared inadmissible. Third, measures were introduced to deal more effectively with repetitive cases. Amendments were made so that a single judge could reject plainly inadmissible applications, while prior to this only a 3-judge committee could be making such a decision. It is important to note that under the aegis, a single judge may not examine applications against the state which nominated him. Previously, the committee could only declare the case inadmissible, but could not decide on the merits, which could only be done by chambers or the Grand Chamber. Protocol 14 also provides that when a committee decides on the merits of a case, the judge nominated by that state is no longer a compulsory member of that committee. Protocol 14 empowers the court to declare applications inadmissible where the applicant has not suffered a significant disadvantage and which do not raise serious questions affecting the applications or the interpretation of the convention, or important questions concerning national law. The European Commission for Human Rights is now allowed to interfere or intervene in cases as a third party, providing written comments and taking part in hearings. Protocol 14 also allows the Committee of Ministers to ask the court to interpret a final judgment if there are difficulties in its execution. The Committee of Ministers can, in exceptional circumstances, with a 2/3 majority, initiate proceedings for non-compliance with a final decision in the Grand Chamber. Article 17 of Protocol 14 allows the European Union to become party to the Convention. The Court of Justice of the European Union, that is ECJ, is not related to the European Court of Human Rights. However, since all EU states are members of the Council of Europe and parties to the Convention, there are concerns about consistency in case law between the two courts. The ECJ refers to the case law of the European Court of Human Rights and treats the Convention on Human Rights as though it was a part of the EU's legal system, since it forms part of the legal principles of the EU member states. The former judge in respect of Cyprus, Lokis Lokandis, wrote that by introducing in its rules a bureau, the court created a separate collective organ that had nothing to do with the structure of the court. This is in accordance to the court's organs according to the Convention. Lokis Lokandis criticized the court for reluctance to find violations in sensitive matters affecting the interests of the respondent states. The British Lord Hoffman argued in 2009 that the court has not taken the doctrine of margin of appreciation far enough. He said, I quote, being unable to resist the temptation to aggrandize its jurisdiction and to impose uniform rules. It considers itself the equivalent of the Supreme Court of the United States, laying down a federal law of Europe. Lord Hoffman considered that the ability of the court is to interfere in detail of domestic law ought to be curtailed. He was in 2010 joined in criticism by the President of the Belgian Constitutional Court, whose name was Marc Bossuet. Marc Bossuet, who in 2014 also criticized the court for being judicially activist, as expanded the guarantees of the Convention to issues that clearly were not included in the Convention nor intended by the framers. Bossuet especially criticized the court's handling of asylum cases with respect to Articles 3 and 6 of the Convention. There was also criticism from Russia, a country held to be in violation of the convention by the court in many decisions, is frequent. The court's judge in respect to Russia, Anatoly Kovler, noted, I quote, I dislike when the court evaluates non-European values as reactionary. This was in the case of Refa versus Turkey. The chairman of the Russian Constitutional Court, Valery Zorkin, pointing to the Markin versus Russia case, stated that touching the national sovereignty, the basic constitutional principles. Even though the court has been able to achieve considerable success in the arena of human rights, it has been able to guarantee certain rights and due of people. It can be safely be stated that it is not away from criticism as been seen in the above. Thank you.